Welcome to this free immigration help channel. Today is May 11, 2023, and we're getting into the volume 89 of me answering your immigration related questions. As you can see, I have all your comments pulled up in front of me. As always, I'm going to begin by saying I'm not an immigration attorney. This is not legal advice. All the information that I provide in these videos on this channel are directly from official government sources like USCIS and of course the Department of State with their visa bulletin. So let's start with the very first comment. From Ivory, just saw the visa bulletin for June. It's a copy and paste. Wow, no way. So looks like, let me see. Oh yeah, wow, the brand new visa bulletin for June is out. So looks like I will be making a video on that specifically a little bit later today. But from what it sounds like, Ivory already looked into that and it's nothing much changed. So I will be making a video on June visa bulletin. We'll compare it to May. Sounds like it is exactly the same stuff, which is not very good news, but we'll see. We'll do the examination. Ivory, thank you very much for bringing this up. I really appreciate this. All right, let's move on to the next question from Patricia P. Hi, me again asking questions. Hope you don't mind. Patricia, not at all. As many questions as you have, always welcome, and it goes for everyone who's asking questions. As many questions as you have, you're always welcome to ask. As you know, I'm preparing to gather the documents for my daughter's case. I was looking over the DS-260 form and I have a couple of questions. My daughter was married for 5 years but is divorced, and I filed for her as unmarried child over 21. Would she have to submit marriage and divorce papers? Yes, definitely. Also, when she came to US in 1999 with the whole family, she had overstayed her time here but went back to our country. Would this come up in the interview and would it be a problem for her? So it will definitely, well, I can't say definitely, it really depends on the, so many different factors that go into these interviews. These consuls, they wake up sometimes on the wrong foot and they don't, in a bad mood, and they give problems to everyone. Sometimes they're good, nice, and very polite. A lot of times, interestingly, a lot of times whenever it comes to immigrant visas, especially for family for family petitions, a lot of times, from what I hear at least in the experience, people telling me and my own experience, they have been very polite. However, when it comes to non-immigrant stuff, not so much. So hopefully no problems. It might come up, but even if it does come up, just tell her to be honest about it, explain the situation, explain what happened, why it happened, why she overstayed. I'm sure it's nothing serious. And because it's been 23, 24 years ago, a long time ago, it's not going to affect in any negative way. It shouldn't affect, at least. You can't say for 100% sure because it's always at their discretion to make the decision. But usually, most of the times when it's been such a long time, and the worst case scenarios, usually it's 10 years. If there is some kind of, if you overstayed your status, if there is some kind of entry ban, if the visa was revoked or, void, became void. A lot of times there is a inadmissibility clause that they put for 10 years. That's like their worst kind of, okay, I don't want to call it punishment, but really that's what it is. But since it's been more than twice that long that time, it shouldn't be any problems. But yes, being prepared just in case if it does come up, that question, just having a good brief explanation of why that happened, it would definitely be beneficial. So let me put this and we're going to move on to the next question from Zoe Kevin. Hello, thank you for the wonderful job you're doing. You're very welcome. Thank you for watching. I'm an immigrant. I just got out of my fingerprint appointment for my I-589. All right, application for asylum, that is. Yes, and withholding of removal. I always confuse I-589 and I-539. My mom has her green card and the sister is citizen. Could one of them do a status adjustment for me before I get my green card? If so, what is the process and how long can it take? Thank you for answering me. Of course, thank you for asking the question. Actually, really good question, because both your mom and your sister can file I-130 petition for you. So if it's your mom filing, then yes, since she's she has a permanent residence, And if you're over 21 and unmarried, she can file for you. Or if you are under 21, she can file for you. Sister, as a citizen, she can file for you regardless whatever your status is. Now, for both of the situations, it's going to be I-130 petition. I actually do have a video on this channel, and most of the questions that I get on this channel and most of the videos, at least as of recent, that I have been making in this channel are about family reunification petitions, which is I-130 petition. I will show you where to find this petition. I'll use this as an opportunity to demonstrate the navigation of USCIS.gov, official government website for US Citizenship and Immigration Services. So this is how it looks like. You can find this link in the description below. On the top of the navigation menu, you will click on Forms, and then you will go to All Forms, and then you'll have all of the immigration forms. You can just scroll down to I-130, or you can type in 130, and it will come up. And the nice thing about 130 is that you can file it online. So you can, either your mom or your sister, they can do it today. I will tell you about which one is better. Who filing for you right now, as of right now, is better. That will be your mom, by the way. So all of this, how to fill out this application, just the whole process, describing the whole process, what are the steps involved, you can find on this channel. I have videos, I think I have a playlist called Family Petition or Family Immigration. I think it's called Family Immigration, and all of the videos in there just start from the very beginning, how to file the I-130, and then you can check out, further into the process, what is involved in this whole, because it takes quite a long time, but it's definitely much better. It's much more, let's say, streamlined of a process, at least compared to filing for asylum. Now back to who is better filing for you. Whenever it comes to US citizens filing this family petition for their siblings, for brothers and sisters, this is the forced priority category. And again, you will be dealing, if you're dealing with a family reunification petition, I-130, you will be dealing with the visa bulletin. This is the the page from the Department of State that basically shows which dates, as of currently right now, being processed when people file them, right? So there's a graph B for filing dates, and there's a graph A for those who were already documentarily qualified. And again, this sounds like, because you're pretty new to this petition, it sounds like, weird words, but you will quickly understand all of it, and you will be like, you'll navigate pretty easily. It's really not that hard to understand. So forced priority category, it takes the longest, and we're talking about, over 10 years. That's how long they take when US citizens petition for their brothers and sisters. So it is much better, much faster for your mom to file that petition for you. So if you're under 21, you're going to be in F2A category, which is, it's pretty fast. If we look at the visa bulletin, for example, right now people are getting their immigrant visas that filed back in September 2020. So roughly about 3 years, which is, pretty good. It's pretty good. Whenever it comes to family preference categories, that is pretty good. Or if you're over 21, unmarried, then you're going to be in F2B category. There, the time is a little bit longer. People are waiting about 7 to 8 years. But still it is much better than, brothers and sisters, because brothers and sisters right now are getting immigrant visas, those that have been their priority dates back in April 2007, which is 16 years, which is, crazy long time. So, yep, you got some things to consider. Obviously, I would recommend check out a few of the videos so you're familiar with the process of family reunification. And then along the way, if you have any questions, you're more than welcome to ask as many questions as you have. All right, let's move on to the next one. This question is from Sergut. I don't know how to read it, but I know it's Sergut because he told me himself. Sergut, appreciate it. And thank you for being publicly subscribed, as always. He says, "Hi, brother. Hello, I haven't gotten an interview appointment yet. My priority date is December 2016. I-130 approved February 2022. F2B. Okay, all right. NVC documentarily qualified date February 2023, so just a few months ago. Now I am ask B2 visa. Yeah. So if I got a US tourist visa and go to US, maybe NVC scheduled my interview for my F2B visa. In the middle, do I have to return to my country for the interview, or can I turn my interview to US? It's a good, excellent question. So in some situations, when NVC is aware that you are not back in the country where you're trying to get the immigrant visa from, and instead you're in the US, they give you an option to actually switch and have the interview in the United States. Obviously, it's not going to be in the embassy, it's going to be in one of the immigration field offices. But yes, absolutely, you have such an option. Personally, I have never seen anyone do that on B, just regular, non-immigrant visitor visa like B1, B2, or F1. Actually, you know what? I had a comment from somebody who was on F1 and they had an interview here in the United States. So I've seen F1, I've never seen B1, B2, but if F1 gets that option, then B1, B2, because it's very similar non-immigrant status, right? It's just one is the student and another one is the visitor. The only difference is, and the only sort of a little bit of a problem that I see with this is that F1, usually you are given the visa, the duration of stay for a year to attend the university. With B1, B2, it's 6 months, which is max. So you might not have as much of the time for all the scheduling that is involved to actually stay here. You might have to file the extension, which honestly I wouldn't recommend dealing with an extension. I would rather just go back and do it in the embassy, especially if they already scheduled it. I wouldn't try to reschedule it, because by rescheduling really anything, you're creating the delay on your case. And we've been waiting for so long, and you're an F2B, so you're already waiting since 2016. It was for 7 years, 7 years now. So we really don't want to do anything that creates more delay on our case. But yeah, absolutely, definitely, I would honestly recommend to everyone who's waiting for their I-130 petitions. In the meantime, if you don't, because it's a little bit of a risk, when you're applying for a non-immigrant visitor visa, B1, B2, visitor for pleasure, and visitor for business, which most of the times they just put B1/B2. I don't know. Sometimes they put just B2, sometimes they put both. It's the same thing, really doesn't make it much of a difference. There is always a risk when you're applying for that B1, B2 visa, when you have an existing I-130 petition in your name. And kind of right now, this is a dilemma that I'm having with my brother, who I'm petitioning for, because he already went several times and he was denied this visa before we had the I-130 petition. After I got my citizenship, I petitioned for him, and after that he did not try to get the B1, B2 visa, and now he's kind of worried about going back trying to get the B1, B2 visa because he doesn't want to get denied again. And there is sort of a more chance to be denied. Why? Because we all, I'm not just talking about me and my brother's situation, but everyone who is starting I-130 petition, we are starting an immigration petition. So you're already saying that the person that you are trying to reunify, your family, you are trying to get them to immigrate to the United States, all right? So there is an immigration intent. And then this person goes into the embassy and says, I want a non-immigrant visa. So you see how it creates a contradiction. Now, a normal, I would say rational consul who is taking the interview, he or she would look at this and say, I understand, your brother or your mother or your father or whoever your family is petitioning you for you, and meanwhile, because this petition takes years, you want to go and visit them. You're not planning to overstay, you're not planning to do anything illegal, you just want to go travel, no immigration intent, just to be with them, spend some time with them, and then come back and continue waiting for your petition to be approved for immigration. Unfortunately, a lot of times you don't get that rationality from such people, and a lot of times, these petitions, these not petitions, the requests for non-immigrant visas are denied, which is completely unfair. Honestly, it's completely ridiculous. It's moronic. That's what it is. I really hope that Department of State with Department of Homeland Security, or whoever's responsible for, that specifically, it's Bureau of Consular Affairs. So I think they are the ones who obviously participate in coming up with all these different visa classes. But I really hope that one day someone who actually more or less understands the process, they come up with a dedicated non-immigrant / immigrant. It really doesn't matter what the classification of that visa will be. Probably non-immigrant, because it's temporary travel, temporary, for those who have a family immigration petition pending, and they are more lenient on giving those out. If you have an immigrant petition pending, here you go. Here's the visa. You can go and you can travel and you can visit your family. And if you plan to overstay and not come back, well, you are putting yourself, it's your choice. You're putting yourself in, not a very good situation, because then you will have to deal with those interviews for a green card, for citizenship, and most likely you're going to have big problems. So it's not like there are no repercussions for just leaving and overstaying and not coming back. We do deal with those repercussions, and we all understand them. Most people are not going to do that. I don't know why they treat us like everybody does that. But yes, sir, good. Sorry, I got off on the journey with your question. But yes, I would definitely recommend trying. If you don't mind, what is it, $150, $160 to go and pay for that, non-immigrant visa. Because if you can get it, great. You can come to the United States. You can hang out with your family. If you have to go back, no problem. You'll go back. You'll come back again. Travel back and forth, while this petition is still, the I-130 petition is still pending. All right, let's move on to the next one from Ivory. Ivory again. Hey, question. I'm documentarily qualified since October 2020. My priority date is 3rd of March 2015. F1. Country Guyana or Guyana. I think Guyana is pronounced. Just a time. Guess how much more of waiting for interview. Thank you in advance. Ivory, thank you for your question. Let's take a look at the brand new visa bulletin from June. Brand new. Sounds like a copy paste from Ivory, actually, she says. So let's take a look what it shows us. Man, I'm kind of really disappointed that nothing moved in the visa. I don't know yet. I haven't checked, but I do believe Ivory, because she has a case herself. There's no reason why she would. She definitely cares about that. Man, I really wish it moved, but it didn't. Okay, documentarily qualified since October 2020, so we know that, and we know that she's F1, and we also know that it's Guyana, so Guyana is all chargeability, so we're going to take a look at the graph A. So if we're looking at the graph A, December 14, right now they're giving out immigrant visa scheduling the appointments for those who have had their petitions filed and accepted by USCIS back in December 2014. So hers is March 2015. Okay, so March 2015 and they're December 2014, so that is January, February, wow, so like 3-4 months. So Ivory, you're looking at like 3-4 months. You're literally almost right there. F1, all chargeability, December 2014. Just a few months and you should have your interview scheduled. Honestly, I would recommend, because it is so close, I would recommend reaching out to NVC, submitting a public inquiry. Now I'm gonna show how to do that. If you probably know, but just in case for someone who doesn't know, this is the visa bulletin. You will find this link in the description below. Once you click on it, you will see this page. From this page, we're gonna click on Contact Us, and I'll open it in a new tab. And then we're gonna scroll down a little bit and click on US Visas Contacts. Scroll down a little bit, you will see this table, and at the very first row, you will see in the third column, Public Inquiry Form. Click on that. Scroll down just a tiny little bit. Online Immigrant Visas Inquiries only, right here. Public Inquiry Form. Click on that, and you will have the Public Inquiry Form. So here, you will enter your NVC case number, beneficiary's full name, beneficiary's date of birth, petitioner's full name, who are you, petitioner or beneficiary, email address, and then in your inquiry you can say, hey, just be polite, be professional, say, hey, I was documentarily qualified back in when you were documentarily qualified. Let's see, you were documentarily qualified back in 2020. So almost 3 years documentarily qualified. According to the visa bulletin, my interview should be coming up, but I still have not heard anything. Can you please let me know when my interview is going to be scheduled? And just to give them a little bit nudge. A lot of times their response is very boilerplate, but that is fine. That is fine because you kind of give them a little bit of a reminder that you're staying on top of the case. It is always good to do. Once in a while you want to follow up, you want to check on the status, you want to reach out and make sure that there is no, because I don't want to scare anybody, but I have seen some situations where a person just submitted an application and kind of let it into somebody else's hands and do whatever you want to do, and they've been waiting and waiting and waiting and waiting, and eventually they found out that application, they don't even know what happened to the application basically, because it took way longer than any of the applications in that particular, whatever the application was for. That's why it's important to stay on top of the case and once in a while file these inquiries, submit the, if your case is still with USCIS, then submit, case inquiry with USCIS. And also you can call always to your local US embassy in Guyana and see if they can tell you when approximately they have, how they're scheduling for immigrant visa interviews. Look for family preference categories, for family categories, for family immigration in general, immigrant visas. Because sometimes, in some situations, they can actually give you that information. I've seen that happen. A lot of times they don't, but if they do give you that, well, that's nice. But even if you don't do any of that, 3-4 months, Ivory, hopefully, and you should be scheduled your interview. Please come back though to this channel and let us know that the interview was scheduled, went successful, and you got your I-551 stamp. And because it's good, it's good to get questions because it gives me the ability to answer, and hopefully my answers are helpful. But it's also good to read the success stories. Let's call them that. All right, let's move on to the next one from, okay, looks like 2 questions or 2 comments. So this is continuation. Let's start with this one. Hello, I'm a US citizen and the petitioner for I-130, F4 category. So F4 category is force preference category for brothers and sisters of US citizen. This is what I have, and this is the longest one that takes absolutely forever. Brother as main beneficiary or applicant and his wife and family of 5 total with 3 unmarried kids protected by CSPA and who's been documentarily qualified since August 2021. Nice. Congratulations. Wow, that is a huge milestone. When can their US appointment interview at the US Embassy be in the Philippines? Please, as we have been waiting too long, almost and will be close to 2 years. Yeah, 2 years after becoming documentarily qualified. But even before documentarily qualified, I mean, you guys must have been waiting for a very long time, like 14 years? I don't even know. Philippines, they have their own separate chargeability area. So we're going to take a look at the visa bulletin right now. And then Maria says, hi, continuation. I'm here from New Jersey. Thanks. Got it. All right. So let's take a look at the visa bulletin. We know that, we don't know the priority date. Priority date would be helpful. Let me scroll down. No, that's from somebody else. Okay, so we don't know the priority date, but we know that it's already documentarily qualified as of almost 2 years. So let's see what we can find out. So Philippines, they are way back on these. So they're 4 years back and about 5 years back on for actually getting the appointment scheduled for the interview. So let's see. We don't know the priority date. Maria, if you can come back, if you can submit a follow-up comment with the priority date, that will be really, really helpful. But because we know that there is roughly 2 years that elapse after your brother was documentarily qualified, we can more or less do some rough estimates on this case. And I'll explain why. So if we look at the Philippines, they have separate chargeability area. F4, we have April 2004. This is the priority date that is right now basically getting the access to the NVC portal. All right. So Maria's brother was already documentarily qualified. So they already got the access to the NVC portal, and it's been 2 years since they were documentarily qualified. So if we compare this date to the date A, we see that there's a difference of April and August. 2 years and May, June, July, August. 2 years and 4 months. There is a difference between the two. Between getting the access to the NVC portal, to not becoming documentarily qualified, but where the NVC portal opens up fully, where you can start the process of becoming documentarily qualified. And then getting the actual interview scheduled for immigrant visas, because they are available now, August 2002. So that is 2 years and 4 months. For Maria, it has been August. It's in August 2021. So right now we're May. So we are under 2 years. So it's not even 2 years. So we are, let's see, August, May, June, July, August. So 3 months roughly. So 3 months back. So Maria, you're looking at about roughly, I would say, between 6 to 8 months. You are looking to wait for that availability of the immigrant visa. If you let me know in a separate comment, if you can, just don't respond to my comment within your comment, because I don't get notifications for those. The initial priority date when the I-130 was accepted by USCIS, so it's like way back. Your priority date would be back in like 2003, I'm thinking maybe 2002. I don't think it's 2004, because you're already documentarily qualified as of 2 years. So I would say somewhere in 2002, possibly 2003. But yes, as you can see, there's a difference between portal open and immigrant visa available of 2 years and 4 months. So that's what roughly you will be waiting for the availability of the immigrant visa after you are documentarily qualified. About 2 years and 4 months. And you have been waiting close to 2 years now. So next 6 months, I might be possibly by the end of 2023, you get the interview, your brother gets the interview, possibly in the beginning of 2024. But I gotta say, huge milestone, waiting very, very long time. I mean, it's really big, becoming documentarily qualified in F4. That's what I'm looking forward to. But I have another, over 10 years to wait on my petition. So, but yes, Maria, if you can come back, if you want to, I will re-verify my own basically estimate with the priority date. But I think that should be pretty roughly accurate. All right, let's move on to probably last question for today from Mohammed Taslim Majid. Sorry if I'm mispronouncing the name. Thank you for your clear explanation. You're very welcome. Thank you for watching. I'm glad this was helpful. I have a scenario. Let's say B1, B2 visa holder apply for an extension just 1 month before the I-94 expiry. If after 11 months USCIS send a letter saying they approve the extension for another 6 months from the initial expiry date, does this mean the new extension is already expired and applicant already overstayed for 5 months? Can you please clarify this? Mohammed, thank you very much. It's excellent question. Excellent question, and the answer is, it will show you how ridiculous right now, USCIS is with a lot of things. But yes, what you're saying is yes, it's pretty much it. The only thing is that they're not gonna tell you that you have been here, you are here illegally. Let me try to kind of explain it. You're not here illegally, and yet you are outside of the duration of stay. Okay, so if let's say you have a B1, You came here, they gave you 6 months duration of stay. You filed for the extension, let's say in the beginning, as soon as you came into the country, you filed for the extension of stay. You've been waiting and waiting and waiting, and Muhammad is spot on. It takes about a year for these applications to be reviewed. So you file it, you wait for 6 months. Now you are outside of the duration of stay. Interestingly, they can come after you basically anytime they want. It is at their discretion. Anytime they want, they can start removal proceedings against you. 99% of the times they don't. All right, you are remaining in the country, but you are still considered outside of the duration of stay. You are still considered basically, remaining in the country illegally. Why? Because the application for extension does not give you any kind of status. It doesn't even give you the status of regular B1 staying in the country, basically. There's nothing. I recommend carrying the receipt regardless, just in case if there's some kind of questions. Carry it with you if you are filing the extension and if you are outside of the duration of stay. But it's still a big risk because you are outside of the duration of stay. Now, whenever it comes to them approving the extension, the maximum amount that they can approve the extension for is another 6 months. So yes, even if you filed in the beginning and it waited for a year, you might get basically a response from them saying, oh yeah, we extended. And interestingly, they extend the 6 months, right? If they give you the maximum, another duration of stay of 6 months, they extend it from the date of the expiry of your previous duration of stay. You see how ridiculous this is. It means that, yes, if you file 1 month before the expiration, you waited for a whole year, you get the letter, oh, yeah, your duration of stay is approved. And then you realize that it expired already. That, yes. The only plus side to all of this ridiculousnose, and that's not from me, that's USCIS. You can find it on their website. I don't know where exactly, but USCIS, they have those PDF documents that they always update on kind of like FAQ, like frequently asked questions, on all these different applications. And if you really want to dig into it, you can find that information. It's there. But the only good thing about all of this is that while you were waiting all this time for your application to be reviewed, if your application is approved, no matter how much you overstayed, all of that duration is covered. However, it is only covered up until you get that decision. After you get the decision, if the duration of stay that they extended is already expired, that's it. You cannot remain in the country any longer and you have to leave the country. And in the airport, you will have to show your, look guys, I was filing the extension of stay and I got my application approved. So all this time I was here legally. Okay, here you go. Here's the receipt. And then they're not going to, basically give you the bar or ban or whatever, or visa revocation. If it is denied though, yes, they do immediately start the removal proceedings. When you leave the country, they revoke your visa, so it's not good. It's definitely not good. So that's why I say all the time, if you do the extension only if it is absolutely necessary. It's an emergency, serious situation. You have to stay here with your family or something along those lines. In those situations, do that. But if you don't have to, then I wouldn't even recommend bothering with this, because it is for now it is pretty ridiculous. If they reviewed it within 30 days, 2 months, or like they say, if you go to USCIS website, they recommend filing this extension at least 45 days before the expiration of your duration of stay. Like they review it in 45. If they reviewed it in 45 days, then no problems. Then yeah, it's good. There is purpose to it. But right now, it's completely useless. That's what I'd say. But Muhammad, thank you very much for bringing this up, because this is a really, really good question. And people dealing with the extension of stay, I think they really need to know, what they're getting into. So thank you very much everyone for asking your questions for today. Like I said in the beginning, if you have any follow-up questions, do not hesitate to ask them. Just make sure don't respond to my comment within your comment, because I don't get the notification for those for some reason. And I'll probably be doing in a couple of hours, I'll do another video today on the brand new June visa bulletin. That is, looks like didn't change much, but I will do the comparison between May and June, and we will see. We'll discuss the, give some rough estimates, and hopefully will be helpful. But thank you everyone for watching. Always appreciate your time. Thank you for your questions. God bless, and I'll see you in the next video.